Hi, I'm Amy, Head of Learning and Development and Support at Trade. So let's jump right into it because it is quite a big and lengthy topic. And today we're going to be coming up, talking about something that unfortunately does come up at the worst possible time. And when a client has already gone into business rescue or has already gone into liquidation, and now you're thinking, oh no, well, what do we do now? Okay, and that's where we're currently sitting. So today we're going to go ahead and we're going to cover all these processes, what they actually look like, how they differ, what's the difference between these two, and what do we do when we get a notice? So just as a disclaimer, myself, Martin, Neil, we are not lawyers. We're just giving you our opinions, our views, our history. And of course, we always refer this back to if you are looking to or in a position where you're having to deal with a customer of yours that's gone into business rescue or liquidation, definitely reach out to an attorney and see how they're going to help you. So, at the beginning of the program, I just want to find out, if you want to pop this into the chat, how many of you have had a client go into business rescue or liquidation in the last 2 years? And then, let's have that discussion around what did you do about it? Because this forum is not only to hear from myself and from Martin, but to put together a session where we're all working together. We're all in that business to business space where our clients trade with us on credit and where we may come into contact with companies that happen to you. Hopefully it doesn't happen to us, as in everyone on this call, but, it does happen with some of our debtors. Okay, so let's jump right into it. I see there's a comment in the chat. Just want to double check what that is. Okay, no, nothing we need to cover. Okay, so what are we going to cover today? The first section that we have is business rescue versus liquidation. So the difference of what that is, what triggers each one of them, and why this matters. So are not the same thing. And a lot of people seem to think that they could be interchangeable, but that's the first mistake. Okay, so they are very different. It means the business runs or does not run very, very differently. So the second thing we're going to look at is your rights as a creditor. Yes, Martin.
I mean, just to give you some perspective about business rescue. Now, in the past, it used to be called placed under administration. The business was placed into administration. And the same person, in other words, a liquidator, used to run the business in under administration. And there was no real motivation to rescue the business because they used to administer the business and try to rescue the business. Because when does liquidators make money? When they liquidate the business. And that's where this new thing came from, where they separated the two, gave it a new name and said, we will now have different people doing business rescue than to the people that does liquidations. So you have a business rescue practitioner that does the one, and you have got liquidators that does the other. We can carry on. Thank you.
Perfect. I'll come to Joe's comment at the end. Okay, so we're going to be covering what is your right as a creditor. So during the business rescue, what does that mean? The moratorium, the freeze of the legal action, what does this mean to become? Do you become powerless? And we'll unpack that when you can and when you can't do certain things. Then we're going to move on to the order of the creditor's preference. We have spoken a little bit about this in a previous session. So this is about where do you fit in on that queue, who gets paid first, who gets paid last, and understanding what that means for you. And then section 4, we're going to be looking at what to do when you receive a notice and the proactive steps you can do before any of this happens so that we can have a look and see, this is where the real value comes in, where we want to make sure that we're doing things beforehand and not after. Okay, so let's start with the basics. Business rescue and liquidation, 2 very different outcomes and 2 very different sets of rules, but they both start in the same place. A company cannot pay its debt. So that's where it begins. So let's go ahead and break it down. So over here we have business rescue. And the most important thing I want you to understand is the intent behind each process. Okay. Business rescue, so if we look at it, there's the Companies Act of 71 from 2008, Chapter 6, and we can post that for you if you want to go and have a review of that. The goal is to rehabilitate a company from a financially distressed place. So a company is saying, we know we are not making ourselves profitable. We are in a place that we are financially struggling. And we do believe that there is a way to come back from this. Okay, so the company continues to trade under a business rescue practitioner. So the trigger here is financial distress, and it's defined to say that there's a reasonably likelihood that we will come back to be able to pay you, but we may not be able to pay you right now or within the next 6 months, because obviously we're going to need to make some changes internally, and hopefully those changes will result in us being able to pay our debts. Okay, so likely, or it's likely to become insolvent within 6 months. So if we aren't able to rescue ourselves, we may then move into the liquidation phase. Some businesses have taken longer, like we see with Tongaat's Hewlett, Tongaat, which way does it go? Tongaat Hewlett. They were in business rescue for about 5 years before they went down the liquidation route. So they really did try to do whatever they could in order to save that business. And that could be multiple different things. For example, they could come in and say, if you're a kind of chain store, maybe we're going to close down some of our chains. Maybe we're going to change a bit of our product offering and minimize what we do and become, focused in the areas that we're good at. Maybe it's that we have to retrench our staff, unfortunately, and work with as few people as possible. And so maybe these changes then help with their overall cash flow, and that would allow them to trade. And so these are the types of things that business practitioners come in, and these business rescue practitioners come in and they say, thank you, Neil. And they try to help you to do that. So rescue can be voluntary. So a business resolution is filed with CIPC within 5 days, or there could be a court-ordered application by a creditor or a shareholder or CIPC themselves. So once it begins, a business rescue practitioner, or they refer to it in acronyms as a BRP, they take effective control of that business. Okay, so just BRP, business rescue practitioner. Then we have liquidation. So this is part of the Companies Act of 79 to 81, or the Insolvencies Act of 24 of 1936, from way back when. And the goal is to close the company down. So a liquidator is appointed. The company stops trading altogether. Assets are sold. Proceeds are then distributed among the creditors in order of priority, and the company is deregistered and ceases to exist. So the difference between the two, one has the opportunity to be rehabilitated and to come back into business, and the other, there is no hope from coming back from this, and it is what it is. Sometimes you can go from business rescue into liquidation, but you cannot go from liquidation into business rescue. Okay, so the key difference for you is the business rescue, there is at least a chance of recovery. So a financially distressed definition, this is also a practical monitoring tool. So if one of your clients is heading towards this, in other words, like a 6 months insolvency threshold, that is when you need to act, reducing limits, calling in debts, reviewing their securities. And by the time the rescue is then formally declared, you would then obviously already have lost the best window if you are waiting until that point of time. So when somebody tells you that they're going to business rescue, act very quickly, start looking at whatever you do have so that you can then go ahead and make those changes. Martin, go ahead.
There's a question in the chat box. It says, hi, can you please advise on how business is affected where the directors are sequestrated, but the business status still shows as in business in CPC without notification received about the business rescue or insolvency? When a director is in his personal capacity being sequestrated, all right, number one, he can no longer serve as a director. So he will have to be removed by CIPC as a director. Cannot serve, be sequestrated. It does not affect a business unless he's the sole director. Then it might. But the company is a legal entity on its own. It stands here. It's got a registration number. If it is a sole proprietor, with other words, Martin Petzer trading as Mr. Lawnmower, kaput, gevoelverslauwing, because it's me, I'm the legal entity. If it's a director of a business and he goes insolvent and he is sequestrated, it's not the business. It's two separate legal entities, two different activities. Concern, yes, if he's the director and it's only the as to what's going to happen, because he might then take the business with him and also liquidate the business. However, you will not see an advice on CIPC. They might say the director has been removed, and because it's two separate activities, it's got nothing to do with the legal entity of the business. And it might say that he's sequestrated, but not always necessarily, because CIPC also, Amy has just now said that when you liquidate a business, it is either because the directors wants to liquidate the business, and that's called Section 80, where the business just doesn't serve a purpose anymore, involuntary liquidation. However, in CIPC, you don't see the difference. 88% of businesses liquidated is voluntary liquidation. So it's for you to go and establish whether it's a Section 80 or whether it's normal liquidation. Normal liquidation means they're in distress. They're not going to pay you, or you're going to have to claim. Section 80 means they're closing the business and they got money to pay all the creditors. So you've got to make sure that you are in that category and that you are going to get paid. Hopefully that answers your question, Bernice.
Absolutely. And we can always hopefully cover that a little bit later as well. Okay, so let's have a quick look at this. So, and I don't like this word because it's difficult to pronounce, but how business rescue works and the process that actually happens. So obviously this is if you are in business rescue, you yourself, not the creditor that is owed. So the moratorium has exceptions, it's not an absolute freeze of the business. You can still cancel contract. If a company was already in breach before it began, then you can exercise your rights of set-offs and apply to the court for relief as well. So most creditors don't know that it's not a freeze of their assets. They are still able to actually pay you with whatever funds they have. It may be partial payments, but there can be an agreement that can be reached. Unlike a liquidator, it is what they give you, and it is according to cents to the rand. And here you do have an option to then still discuss what it is that they can afford to pay you and how they're going to pay you. So basically a payment plan. So step 2 is then when when it's been appointed and when it begins the legal proceedings, the enforcement of the suspension, as well as and this is looking at the Companies Act, where you can go ahead and Google that and read the Companies Act for yourself. Then we get that BRP, so that business rescue practitioner is then appointed, and they take control. So they must be obviously licensed and they need to be independent. This is very crucial from the perspective of that you don't want bias. You want to make sure that there's a neutral party and they also know what they're doing, because you're going to try to rescue this business. So you want to make sure that they are objective as well. Okay, so once somebody has taken appointment, you as a creditor can actually have a decision here. You can object to the appointment if you have any grounds. So that is important to note. So if you feel that you would be at a disadvantage as a result of it, therefore you can go ahead and object. Okay. So then there comes the rescue plan. So within 25 business days of appointment, they need to be able to, and when I say they, I mean the business, the BRP, the business rescue practitioner, has 25 days in which to set out how the company trades out, what creditors will be paid and when, and then creditors vote on 75% by value it needed to be, that you need to opt out on. So you do get a vote as well to say, they've said, we're going to pay X, Y, and Z. We're going to pay them like this. And you can then say, no, I actually have much more that's outstanding towards my business. And therefore, I should get majority of the share. Or I'm willing to wait my 6 months, but I'm going to charge you an additional fee, for example. Yes, Martin.
It's at this point, Amy, where it can tilt the rescue into a liquidation stage, because
Yes.
you can either support the business rescue or not support the business rescue. If you support the business rescue, it means you got to continue supplying in stress debtor so that they can continue trading, so that they can generate income, so that they can pay their creditors. If you do not
Correct.
support it,
Mm-hmm.
75% of it, then it means that we are saying they're not going to be able to be rescued. So you
100%.
are tilting the decision into the different direction. So that is, yeah, it's very critical for you as a creditor then to decide, is this a feasible plan? Is this a workable plan? Is it going to help us? Is it going to rescue the business? However, if you decide not to support the rescue and it still goes through, you're going to sit on the sideline and wait. You're going to be one of the last to be paid anything because you don't support. They're going to ring fence your debt and you're going to wait. If they liquidate, then eventually you might have a claim. But if you're unsecured, Amy's going to get to that now. But if you're a secured creditor, then of course you exercise your rights. But this is where it's a critical part. Think about it. Thank you, Amy.
Absolutely. And that's point number 5, to say whether or not the plan is going to be supported or not. And then if not, and they don't see that this is a good plan, then they may choose to liquidate from here. I do want to say that the first creditors meeting usually takes place within 10 business days of the appointment of the business practitioner. So just giving you a bit of a time frame to say up until 10 days, once they've notified CIPC, they have 5 days. From then, within the first 10 days, they're going to have the creditors meeting where you can look and see whether or not who's been appointed, whether you agree with it, whether you want to object with it. Then there's an additional 25 days in which they have to present the plan to you. Obviously, if you weren't in the first meeting, you surely won't be in the second meeting, and therefore you won't have an option to decide whether or not this is the route that they should be going. And especially if you're a key supplier to this particular customer, you definitely want to make sure that you're there. Okay, so now that we know how the process works, let's talk about the question that hopefully everyone in the room is really asking: where do I stand? And I'm going to get, am I going to get my money back? And so let's go and have a look at these different options, which is what Martin was alluding to earlier. So who gets paid and in what order? Okay, so the order of creditors is, the most crucial slide in my opinion. And this slide makes credit managers sit up hopefully straight, and or CFOs sit up straight and say, let's go through both scenarios. Okay, so in liquidation, the Insolvency Act of 24 of 1936, it states the following. So secured creditors, that's mortgage holders, pledges, notarial bond holders, they are paid, first. So that's the most important. So if you are one of these types of suppliers and you are a secured creditor, you will be paid first. Next comes preferred creditors. So these are people like employees, so wages, leave pays, SARS and PAYE, as well as VAT, landlords, up to 3 months of rent, depending on specific conditions. These are considered preferred creditors. Okay, and then next comes the concurrent or unsecured creditors, and this is usually the category that we fit into, which is trade creditors and suppliers. And whatever is left is divided up pro rata. So often it's, as I said, it's cents to the rand. For those who are very young and don't know what cents are what makes up a rand. And so, and we used to have like 10 cents and 5 cents and 2 cents coins. But it is cents to the rand, and sometimes it's actually nothing, or it is so little that it actually isn't going to make any impact whatsoever. And so you would then be leveraging off your, your provision for bad debt, which hopefully you did. In business rescue, this is the Companies Act of 135, which again, I will post this for you so you can go and research them yourselves. So obviously we have a different set of creditors. So we've got the post-commencement finance. So this is the super priority team. So finance has raised after business rescue began its ranks, and they get almost everything. Okay, so that's the first one. This is the post-commencement finance. Then the next person that gets paid first is, of course, the business practitioner, the business rescue practitioner. Their fees and their rescue costs, they get that first. So now we move down further down the queue than we would even if it was a liquidation. Then we've got the pre-rescue secured creditors. So these are people that have traded with us before we went into business rescue. That then becomes the third in line to get paid. So if you are one of them, then you are going to be the third in line. And then we've got the pre-rescue employees. So obviously everyone who was working for the company, these are unpaid wages that happened before business rescue, and those people are going to get paid. And of course, a part of that will also be like retrenchment packages and anything that needs to be paid out if that is the route that they choose to go. And then, of course, we've got us right at the bottom there at number 5. And these are the unsecured creditors, which is usually where we sit. And this is, we're last in line here. So the critical point that we want to make here is that Business Rescue's plan can propose paying concurrent creditors at least 20 to 30% of the rand, which is higher than that of what you might get if the company is liquidated. So if 75% of the value of the vote is for you, then you are bound to get something. So you may not get everything, but you will get something versus a liquidation where you are going to get rands to the cent, cents to the rand, and you may not get anything that is material. Martin.
Yeah. So Amy, this is where the difference also comes in between liquidation and business rescue. Business rescue
You froze there for a second.
Critical assessment. Am I back live again?
You back,
liquidation,
yes,
the liquidator must make a critical decision to say, yes, it's going to be a distribution. With other words, I will have money to distribute between all creditors. Then only must you prove your claim. Because if you claim and you're an unsecured creditor and it's a contribution, it means you're going to pay money in to help liquidate the business. So the question you ask when you get that advice from the liquidator that they're going to liquidate is, will this be a distribution or a contribution? If you're an unsecured creditor. Secured creditor means you've got tangible security, you exercise your right, you recover your money or some of it. But if you're unsecured, do not prove your claim until you've established whether it is distribution or contribution. Ask the question. If you want to know more about this, please don't hesitate. Ask an attorney, ask me. We can have a chat about it. I don't want to take up too much of the time here. With Business Rescue, they carry on trading. That's whether you want to support the rescue or not, but that's your business decision that you got to make.
Absolutely. And I see we do have a question in the chat from Yaku, who said, can a PCF creditor be paid from secured assets? So, and then the question goes to say, this would mean that the secured creditor can potentially be in the worst position, that of the liquidator.
A secured creditor has got the rights to exercise their rights when it goes into liquidation. So what it means is as follows. Let's say you have a notarial bond. If I have a notarial bond, it means that the goods, the movable assets, doesn't belong to the liquidator. It doesn't go into the liquidation estate. It is removed from the estate. It belongs to me. It's the same with your reservation of ownership. That reservation of ownership says, my goods are unpaid. It belongs to me. It doesn't belong to the company, and it's therefore. So when you have a notarial bond, it means you've assigned your rights of your movable assets to someone else. So it doesn't belong to you anymore. It's the same with a property. If there's a bond over the property and the property is part of the business, it means I have given my rights. This property doesn't belong to the company. It belongs to Standard Bank South Africa because I have bonded it with them. So you have removed the ownership of that specific product. And the same with debtors. If you have ceded your debtors to someone else, it means although the debtors are the company's debtors, they don't belong to me. They belong to someone else. And they will then call on that session and then exercise their rights in relation to that session. With other words, whatever they collect, let's for instance say the debtors are worth 40 million, but I'm only owed 10 million. So I will collect 10 million, and now the rest of the debtors will go into the estate of the liquidation, and whatever is recovered from that will then become part of the distribution that will be made if there is a distribution. If there's not other secured creditors then stepping in and trying to get some of the money back. But that's in short how that happens.
Absolutely. And obviously, we want you to know this all before you step into that first meeting so that you can then make a decision. Do we prefer to be liquidated or do we try a business rescue? So now we know where you stand in the queue. The next question is, what do we actually do when that notice lands on our inbox? And what rights do we have to protect ourselves during this process? And so let's jump right into that. So business rescue notices. So the immediate steps that you want to be taking. So picture this, you come in on a Monday morning, or I suppose today's Thursday, so you come in on a Thursday morning and there's an email from your customer or their business rescue practitioner notifying you that the company is now under business rescue. So what do we do? And or alternatively, if you are a Tradeshield customer or if you subscribe to a CIPC type alert system, hopefully you know about it before this even happens. So your rights here is you are an affected person. That is the term that they would use for you. It's a formal legal status and must receive written notice within 5 business working days. So you need to ensure that if they don't comply with these rules, that already puts them at the back foot. So you have a right to participate in the creditors' meetings, you get to vote on the rescue plan, and you can access the company's financial information through the business rescue practitioner. So your vote, your weighting is proportional to your claim value. So you have more say if you owed more, and you have less say if you owed less. Okay, so the immediate steps that you may want to take is you may want to stop supply. So do not send another delivery or extend another cent of credit without a deliberate commercial decision. So ongoing supply with someone, you would then need a specific agreement and know that it is still unsecured. So at this point in time, you either want to stop supplying them, or if you continue to supply them, you're going to want to make sure that you understand what your rights are. You may want to switch their terms to then be COD or cash in advance to make sure that if we're going to help them, of course, that's what we want to do. We want to help somebody to rehabilitate. So by stopping supply of your product would then maybe not allow them to trade, depending on what type of supplier you are to the business. So that is something you need to take into consideration and also put that into the agreement. So you may want to pull up a new agreement that you're going to then discuss with the business rescue practitioner. Okay.
Amy,
so you're going to, yes.
Someone asked a question, say, what happens if we don't get notified? So that means you're still going to continue your credit control and you're going to phone them and they're going to then tell you, listen, we are actually in business rescue or we've applied for liquidation. You will then need to ask who the business rescue practitioner is, because they should know, or who the appointed liquidator is. If they don't know who the appointed liquidator is, it's a little bit more laborious. You've got to go to the high court in your region, go there, find out who the appointed liquidator is, and then start your process with the liquidator. But if they've been placed in business rescue and your credit controller phones and they say, we can't pay you, we're in business rescue, speak to Martin, he's our business rescue practitioner, then that's how you will be notified. If it's not an official notification, as Amy has indicated. Okay?
Yeah,
Hope that answers your question.
I think you can also take them to task if you are, have a very large amount outstanding with you and you were not notified, and you can prove that you were not notified, then you can actually take them to task, and then that could maybe potentially change the course of what they had planned to do, because your vote would have swayed it to become a to liquidate the assets and pay you out versus actually trying the business rescue. So you would have to appoint an attorney to then fight on your behalf to do that. So very, very important. But if you don't subscribe to some kind of, alert system that tells you as well, so that you can keep on top of it. I would highly recommend that you do something like that, or maybe a point that your team logs onto CIPC and checks some of your very large customers every single day to just make sure that you're up to date with that, so you're never on the back foot. I'm not saying subscribe to Trade Shield, but if you would like to, you're welcome to reach out to us and have a look. If you are subscribed with us already, then we're doing this for you and you should be getting those notifications. But just to make sure that we're on top of it. So the next thing you want to do is you want to complete your file. So now you're going to want to start compiling all of your evidence that you have. Every invoice, every credit note, the signed credit application, the terms and conditions, signed sureties. So you know exactly what you are owed, down to the rands and the cents. And you have everything documented, and you create this file, and you then say that if somebody were to then, challenge you, you have the evidence already ready. Okay, so that's very important. You're going to want to put together all of this information. You may also want any emails that you have. So for example, if you've got promises to pay, or you've got any type of email communication from the client, that also is considered evidence in writing. And so you can add that into your documentation. Then you're going to want to take all of this information and you're going to want to submit it. So you have to find out when the deadline is, and that should be something they tell you immediately. But if they don't, ask for it so that you make sure that you don't miss it. Otherwise, your claim can be disallowed. So if you have been notified and you don't submit on time, therefore you can be disqualified. So very important that you are very aware of the timelines and you stick to those timelines. Okay, then we're going to want to attend the first credit control meeting. So as I said, within 10 business working days of the appointment of the business rescue practitioner, the first opportunity is to hear the business practitioner's assessment and ask the questions. So your information that you're providing them, your documentation, allows them to say, this is what is owed to this person. Obviously, we're hoping they're looking at the debtor's book, but obviously the one who also is on the ball, shouting the loudest, has everything that they need, you're going to be the person that the business practitioner takes seriously. And I'm not saying that they're trying to not pay people, but you want to make sure that you're ahead of the game, you're on top of it. Okay. And then, of course, you want to engage with your attorney, and especially if your exposure is really material, you want to review your documentation. You may want to reach out to your credit insurer if you are insured, and you're going to want to make sure that everyone on your side is aware of what's going on, so that you can make sure that you are correctly represented in any of these proceedings and or unlikely outcomes that you don't get paid. So a liquidation notice, so that's obviously business rescue. Now we're moving on to liquidation. So what happens now? What do you do now if somebody then sends you a notification? You walk in, it's Thursday morning, you get a notification of a liquidation application that has been awarded, or a voluntary liquidation that has, moved forward. And so as a concurrent creditor, you should receive a dividend only after the secured and or preferred creditors are fully paid. And in many liquidations, as we said before, this is very little or nothing. So create your checklist. So the checklist should look like this. If any of your exposure actually secured, so that's what we're going to want to look at. Is any of your exposure secured? Surety from a director. So this is important. So surety from a director, first of all, you're going to want to check that it's still a viable surety, and it actually does not form part of the liquidation because it is in the director's capacity on his own. It has nothing to do with the business. You can still collect on that surety. So that's something you need to know. And it can be done concurrently with the liquidation that is taking place. So you do not need to wait for the business to be wound up before collecting on a secured asset from a director in their personal capacity. So that is something you definitely need to know.
Remember that, 2 different legal entities. This entity, this individual, this person with an ID number said, I'm standing good for the debt of this legal entity. So now this legal entity has been liquidated, I can go after this entity.
Absolutely. And the same applies for, the acronym is ROT, or retention of title. So if goods are still in, identifiable on their premises, and you trade with a tangible good. Obviously, services are very difficult. You can't exactly go get those back. But if you are trading with tangible goods, you have the retention of title clause in your terms and conditions, meaning that stock belongs to you because it has not been paid for and therefore should not form part of the liquidation. It is not assets of the business, it's assets that belong to you. So very important that you make sure that the liquidators are aware of it. So I would also recommend that you make sure that any stock that you provide is identifiable. So when you have an invoice and a delivery note, on your delivery note, you should state, we have delivered X, Y, and Z. These are the barcodes that belong to it, or SKUs if that's what you use, so that you make sure that every single item is identifiable to whichever invoice. So this delivery note, this invoice, this product, and therefore you can prove that it has not been paid for. Because if you are unable to identify whether or not it was paid for, there may be a discrepancy to say, well, you can't really prove that that invoice is paid and that that stock belongs to that. So make sure that we very much have that retention of title and that we are making good stock processes in our own warehouses as well. Then we're going to want to lodge a formal proof of claim with the liquidator. So once we've got all of our information, like we did before with Business Rescue, we put everything together and we have our proof of claim. And this is a prescribed legal form. So it's not just submitting all your documentation. There is actually a form that you need to fill out. So make sure that you know that, and that will accompany your documentation. And this obviously comes from get your attorney to assist you to make sure that you are filling it in. And of course, very important, do not miss the deadline, because then you miss the entire process entirely. Of course, for a liquidated company, you stop supply anything that is going forward and reverse any orders that are in transit if possible. So if you were set to deliver something today and you've got that notification, see if you can then stop that delivery as quickly as possible. And of course, you want to then look at your provisions for bad debt. So talk to your CFO and your auditors early and do a full write-up if that's necessary to make sure that you have everything that you need. Martin, there's no questions in the chat, right?
Nothing.
Okay,
Nothing.
good. So now we want to go on to protecting yourself before it goes wrong. So everything that we've covered so far has been about what happens once that notice has arrived. But, the single most valuable thing that you can do as a credit manager or a CFO or anyone responsible for trade credit is to act before you ever receive that notification so that you are mitigating your risk before it takes place. And that is something that should be ongoing in your business every single day. So reducing your exposure before that client becomes distressed. So the best collections call is one that you never have to make. So you want to make sure you're not phoning to follow up when somebody's already 60 days over. So you need to make sure that you are applying a little bit of logic. So that's something that Martin talks about, which is know your customer, KYC. And this is vastly important, that you need to know exactly what is going on. And that is your credit controllers on the ground. They are responsible for that relationship. And they need to know exactly what's going on. So an airtight terms and conditions is where we're going to start, and correct credit application. So it's properly worded. You've got retention of title clauses, so that you make sure that you're covered. You've got the correct information of landlord's information if the property is rented. You've got personal sureties of directors as a standalone document that is not buried in your terms and conditions, so there is no room for ambiguity. You want to make sure that that is exactly how you define your onboarding process. And this leads us, I suppose, to that order to cash. How do we start the process, making sure we do it right from the get-go? We have clearly defined credit limits. So if your credit application has not been reviewed since the company started, now is the time to do that. Do not wait. You need to be reviewing your customers, yes, when you onboard them, but there's that ongoing process as well to say things change in people's worlds. And if you are waiting an entire year for one of your largest clients, you're going to be putting yourself at a huge disadvantage and at risk. Okay, so monitor early warning signs as well. So there's financial distress. It really happens overnight. I think I've only encountered it once that it happened where a very viable business was doing really well. Unfortunately, the son had a drug problem. He went into the bank accounts overnight. He stole everything and he ran away. But that is like the exception. Majority of the time, there are signs that show you what is going to happen in this company. So let's start looking at them. Things like paying slower. So they were always good payers. Now they're starting to pay, a little bit later. So for example, a client who paid on 30 days now starts paying on 45 days and then, asked to extend their terms or defer their debit orders. These are signs. Partial payments are signed, bounced EFTs are signed, directors or CFO changes. Now, I know people change jobs, but if you start seeing changes in these key roles in the business, it could be an indication of something taking place and somebody is getting their own early warning signs and they are making an exit before anything changes. Any SARS judgments, so or tax that you need to be aware of. So any SARS or tax judgments that you see taking place, because that's usually where somebody starts to show their true colors. And of course, any key customers that they may have lost. So if they start purchasing differently from you and you ask them, Mr. Customer, I'm glad you want to increase what you're buying from me, but what's happened in your environment that has made this change where you didn't purchase from me like that? Is it that you got awarded a new company, that you've got a new contract? What's happening in your environment? And any 2 or 3 of these things together, your antenna should be up. You should be saying something here is going very wrong. And one of the other things as well is seeing round payments. So if your invoice is 175 Rand and 55 cents and the person pays you 100 Rand, that is an indication of cash flow problems. So all of these things that we've spoken about gives us an indication that something is happening in this environment. Okay. So then you want to act on your overdue accounts as quickly as possible. So the older the debt gets, the harder it is to collect. And that is really something we've always seen happening. So, but insolvency is an age debt that is often, that is something that you see often, that this person, as I said, it doesn't happen overnight. They start to pay slower. It starts to age, and then we start to see that challenge. So anything that is 60 days overdue needs to be escalated to everyone in your team. And this should be a part of your credit policy that Martin will take us through in a couple of weeks' time. You may want to issue your demands. Do not let it sit for 90 days because this starts to feel uncomfortable, and discomfort is a lot cheaper than a write-off. So even though you feel uncomfortable to follow it up, it's going to cost your business a lot more money. And we don't just talk about not collecting the funds. So there's obviously the overdue value, there's the cost of recovery, there's the cost of running your business when you didn't anticipate it. So all of these things are costs that are costing your business money. And at some point you have to put a line in the sand and say, we need to stop doing what we're doing because it's costing us more to collect it than it is to actually like what the debt is actually owed, or we need to go full scale judgments, etc., stop supply, make good on our sureties. Don't wait until you have that area. And of course, we want to reduce limits on stressed accounts. So number one is if you start seeing any of these signs, maybe it's not a matter of stop supply altogether, but maybe reduce your exposure over time. And if you don't see corrections taking place, reduce it further. And if you have that gut feeling that something else is going to go wrong, you stop supply and you change to COD. And the thing is that you want to do this now within the 30 to 60 days overdue, because you're not waiting for the judgments to come. Because if you know about judgments, and Martin, you taught me that this is a historical view. Because somebody who has taken out a judgment, they've now gone into 60 to 90 days, and then you sent a letter of demand, and then you got your attorneys involved, and then you did this, and then you did that. And by the time you actually get to court with that judgment, you're talking about like 9 months to a year later. So a early warning sign is not a judgment, because a judgment, unless it is with SARS, because SARS, what they've actually done is they now have a relationship with the courts to say that their letter of demand, which means it's before the judgment stage, actually goes to the courts and appears as if it were a judgment. And so that is the earliest warning sign that you're going to get about cash flow issues and or non-compliance. So know your customers' financial health, so annual financial statements, which I know is such a tricky thing for everybody, but it also means from yourselves that you also run a business and you also have your own suppliers and your own creditors. Make sure you're also open-minded about sharing your financials. And the change starts with us. If I'm not willing to share my financials, why would you? So that's my plea to everyone on this call, to say that if you are a company that does not share your financials, realize the position you're putting the other person in. And hopefully, if we start making a change, then we'll see that change ripple across everyone that we deal with. So knowing your client's financial health, you can call trade references if that's something you want to do, especially if you're in a very small industry and everybody sort of knows each other. Looking at payment behavior, if you've got trade shields, monitoring flags, behavioral changes, these are things that you want to know that happen now, not in weeks to come. And obviously, if you're not a trade shield user, we're talking about payment profile information. So how does this data pay me versus how does this data pay everybody else? So those gives us early warning signs, because sometimes we are, we're key to this company, and without us, they cannot trade. So they're always going to pay us well, but they don't pay everybody else well. So at some point, it's going to catch up with them, and then it's going to affect us. Okay. So secure your position. Yes.
There's a comment or a statement made by Garth in the comment column, finding that in most cases that we are not being contacted by the liquidator. In other words, they are not advised that this company has gone into liquidation. Now, by law, they have, because the guy knows all the creditors that he owes money to, and then of course the liquidator has to go through that, and of course then. So if you want to guide yourself or guard yourself against that, make sure you get the government gazette on a regular basis. If it's not on Sub-C, if it doesn't get advice through Trade Shield to you that the company's gone into liquidation, because that should happen, but you wouldn't know who the liquidator is. You must make sure that you have a contact at all 9 provinces at the high courts there. And then you phone that contact and say, I believe Martin Petzer Pty Limited has been placed into liquidation. Please advise us who the liquidators are. So it's a little bit laborious, but if it's a value that that is big and you want to recover that, that's the way to go. And also at that point in time, if it's a voluntary liquidation, you can ask the question, is this a Section 80? Have they put the company into voluntary liquidation because they no longer require the business and they got to pay me? Because if that is done under false pretense, you can hold the director and the accountants, whoever they are, personally on a sworn statement in court to say, we're going to close Martin Petzer Pty Limited. It's got enough assets to cover all creditors' expenses. We don't no longer want to trade. That's what voluntary liquidation under Section 80 means. But if it's distressed, then of course they say, we can't pay, let's go for it from there. Got to establish that. And unfortunately, as I said, Sub-C doesn't tell us that. And therefore, a lot of companies how do we know that 90% of the voluntaries aren't under Section 80? So it's not really that companies go into liquidation because of that, but because they just don't require them anymore. Just a statement on that. So, yeah.
Perfect. So obviously we want to make sure that we know our position, whether we are secured debtor or we are an unsecured debtor, so that you know where you sit. And then of course, and this is something that it could be quite interesting, and we do see this, that if you supply and purchase from the same supplier, so for example, I have somebody who uses Trade Shield, but we also buy our computers from them, for example. So if we owe them money and they owe us money, there may be a situation where you could, counteract that, but you would need your attorney to give you that assessment, but it can be quite a powerful protection as well. So make sure that if that is a case that you find yourself in, that is available to you. Okay. And then last but not least, and these are some of the key takeaways that I want you to get from here, that we've covered a lot of ground. And here are the 5 things I really want you to leave with. First of all, act quickly. So time sensitivity, deadlines that apply the moment that notice is received or the moment that you become aware of that situation. The next is to confirm your creditor status and your ranking before you decide on how you want to respond. So are you secured? Are you preferred? Or are you concurrent? The third is business rescue should offer a better outcome than liquidation if we all work as a team to help save that business. And then, of course, the law actually requires the plan to prove this. So we want to be a part of that plan as well. And so keep supporting documentation ready at all times. Make sure, sorry. My phone is ringing. Make sure that you are, you've got your securities. You're constantly checking that those securities are still available and that they're still worth the value that they have and that they have not been given to somebody else, because there's no way to track a personal surety. So somebody can go and, put all this information aside. Make sure that you're keeping up with that as well, especially like with notarial bonds or session of books, to make sure that you are the only person that has been given to. And so you want to make sure that is. And then, of course, strengthen your credit controls going forward. Everything we have covered today is about what happens when things go wrong. The real win is preventing it. And so that comes down to credit terms, monitoring, and documentation. And that is your best defense against making sure that you don't land up in a situation where you are heavily exposed when things go wrong. And so, of course, we always are so grateful to have you. Every session that we have is based on information that we see coming from you. And so your advice is absolutely vital to us. And we would really appreciate your feedback at any point in time. You can get a hold of us, get a hold of your account manager. If you don't trade with TradeShield and you just want to have a conversation with us about something we can help you with, we are more than happy to do that as well. So please go ahead and, reach out to us. We'll pop the support chat, the email address for you over there so that you can go ahead and, be in contact with us if you need anything. I'm going to pop a quick poll. I know Neil did it as well. So hopefully there's only going to be one and not two polls in the chat. Did I do two or one? Oh, okay. So there we go. I think it's yours, not mine. Doesn't matter. But of course, if you feel that you have any questions with regard to business rescue or liquidation that are, things that you don't want to, you just need some guidance on, or you're in that position. But otherwise, we bid you farewell and we'll see you next week, Thursday. And yeah, I hope that this really does help
Amy,
you.
there's a question. Will
Yes.
you be sharing your slides? I know
Yes.
that the recording is always shared. Yes,
Absolutely.
there you have it, God. Amy is going to
Yes.
share the slides in the chat
What
with you.
I will do for you, like you saw in the meeting invite for today, there was a link for last week. So I'll do the same for you there, where there's a link to the slides as well as a recording of today, and a small breakdown in the Knowledge Center. So yes, absolutely, we'll pop those through for you. Okay. Yeah, great. Have a wonderful day.
Well done, Amy. It's brilliantly presented. And I think a lot of information is shared with us today. So guys, please don't get caught. Understand what you need to know, where to get the information, what to do, how to act on the notices. If you don't get notified, where to go and find the information. Make sure that you are one step ahead of them and not them 5 steps ahead of you. Okay?
Absolutely. Absolutely. And go enjoy the sunshine while we have it.
There's something.
Sunshine. We'll just stay online for those that are still completing the poll. Join us every Thursday from 10 to 11.